Tsai Ing-wen's academic dishonesty saga continues in both Taiwan and London. American independent journalist Michael Richardson's case in the UK saw an initial defeat in the tribunal court after the judge cited seeing a closed bundle of documents. The judge said the closed documents contained Tsai's Viva date and examiner names. Therefore, Michael Richardson was handed a loss in UK court on September 13, 2021. However, Birkbeck University's publication of Su Wei-chun's Viva information showed that the University of London's stance was false. It withheld Tsai's information in violation of Freedom of Information Act stipulations. Also, two of the examiner names provided to Taiwan's legal authorities by LSE's Kevin Haynes couldn't have been Tsai's examiners. This has given Richardson much to base an appeal off of. Therefore, his case has gone one tier higher in the UK justice system. Judge Mark West will hold an online hearing to finally get some answers. Last episode, we talked about how the tribunal court handed Richardson a loss after citing a closed bundle of documents. Contained within were supposedly Tsai's Viva date and examiners. That's why the tribunal said there was no reason to publish Tsai's Viva information. But the main issue is, why are Tsai's examiner names in a closed bundle of documents and not on any official documents like a Viva entry form or Viva report? For that matter, where are Tsai's formal Viva documents? On November 26, 2021, the ICO said in a ruling that LSE claimed it did not have Tsai's Viva report. But then, that begs the question, what of the bundle of documents? In its ruling on November 26, 2021, the ICO said that the LSE reiterated in its response that in 1984, all LSE students received their degrees from the University of London, as it did not have the power itself to confer degrees. The University of London was responsible for arranging and invigilating any examinations, and the LSE would receive a notification confirming that a particular student had been awarded a degree. The ruling also indicated that the LSE accepted that it did still retain President Tsai's student record, but that that record only dealt with her activities at the LSE, and this did not include details of her final examination or Viva. Finally, the ruling said, the student record had been examined and no definitive record of the examiners had been found. Whilst one document indicated that a particular individual might have been an examiner, the LSE had no way of cross-checking whether that individual had in fact performed that role, and the LSE considered it unlikely that they would have done so. The University of London and LSE are tossing this hot potato back and forth. In the end, neither institution wanted to claim responsibility for Tsai's Viva records. But the ICO ruling did say that one document indicated who Tsai's examiners may have been. This document must have been included in the closed bundle. In In its ruling, the ICO agreed with LSE's evaluation of the documents it possessed. One of the leftover records may have indicated who Tsai's examiner was. The document mentioned in the ICO ruling is the same one referred to in the tribunal's decision. So it seems that the basis for Richardson's loss in tribunal court was a document that might have but unlikely indicated who Tsai's examiner was. However, LSE had no way of cross-checking whether that individual had in fact performed that role. It's strange that a judge could be sold on such uncertain terms. This document that may have pointed to Tsai's examiners is likely the same one prosecutors in Taiwan used as evidence in court trials there. Prosecutors say they got that information from LSE's Kevin Haynes, who supposedly got it from the school's archives. A set of evidence forged in 2020 said that Tsai's examiners were Michael Elliott and Leonard Lee. However, those two names were most definitely given by authorities in Taiwan. There's no way the archives could have named those two as Tsai's examiners. In 1990, when filling out employment forms, Tsai Ing-wen indicated that her examiners were Michael Elliott and Leonard Lee. This information so far exists only in Taiwan, meaning those records somehow made it to London. Interestingly, the employment forms in question are the only documents that ever indicate Tsai's examiners in her decade-long career as an educator. Richardson exerted pressure on national security organizations when he started his search for Tsai's examiners. They panicked and threw out any two names they could find. Then they had LSE back up those names with documents sourced from the school archives. However, we proved at length why these two people could not be Tsai's examiners. It was then that the wrongdoers tried to pivot. In 2021, Lien Yuanlong pulled out a third name as a potential examiner, Richard Dale. All of this information was fabricated by Tsai and her people. There is not a single mention of Richard Dale as Tsai's potential examiner before 1990. So how did this name mysteriously get thrown into the hat in 2021? The more Tsai insists that her thesis is real, the deeper a hole she digs for herself. As the wrongdoers desperately flounder in an attempt to fend off their accusers, they are backing themselves into a corner. So, in the UK Tribunal Court, the ICO and University of London could only speculate that Tsai's examiners were Michael Elliott and Leonard Lee. As soon as they sent that information into the UK court system, the ICO and UOL proved that they were covering for Tsai. This upcoming hearing in the UK will be a difficult hurdle to traverse for the University of London. If it's confirmed that the examiners indicated to the tribunal court were Michael Elliott and Leonard Lee, that may buy Tsai some time, but that will ultimately make things worse for the schools in London, because if Michael Elliott were indeed Tsai's examiner, that would be academically immoral because Elliott was Tsai's PhD supervisor. However, if the schools deny the information that the tribunal court based its ruling upon, then that'll prove Taiwan and LSE authorities were colluding to cover up academic fraud. When referring to Kevin Haynes' documents, prosecutors in Taiwan said in no uncertain terms that Michael Elliott and Leonard Lee were Tsai's examiners. They even pointed to the exact pages in Haynes' records that said so. If anything, Kevin Haynes sees Taiwan's justice system as a joke, but he probably never expected this case to make it into the UK High Court. In the end, not only will Tsai's academic fraud be brought to light, but the ICO and University of London will be exposed as Tsai's conspirators. The appeal hearing may very well unravel the wrongdoers' lies. It may even force the University of London to walk back its statement on Tsai's missing thesis. The University of London's statement on missing thesis, published on February 2nd, 2022, is the most helpful piece of evidence Tsai has in her arsenal. In the statement, the University of London says Tsai got her degree in February 1984. However, the school gave itself wiggle room when it came to the statement. People who graduate with law PhDs must submit their theses to the IALS and Senate House libraries. Both of those institutions never carried Tsai's thesis, but the university's statement did not indicate what kind of PhD Tsai got, so it might have leeway to say it's normal that Tsai's thesis never made it to IALS or Senate House library. When the University of London sent its rules and regulations for PhD students for the 1983 to 1984 school year to us, it conveniently left out the most crucial 10 pages that outlined expectations for law PhD students. The missing pages are presumably the ones that talk in depth about law PhD theses. The University of London's statement on Tsai's thesis says, while it remains unclear whether copies were deposited with the university's library, that has no bearing on Dr. Tsai's PhD, which was correctly awarded. It seems the University of London wants to skirt the entire thesis issue. According to the University of London, the last known whereabouts of Tsai's thesis was 1984. The school says examiners never returned them to the school. Interestingly, the University of London didn't bother looking into Tsai's missing thesis until 2011, shortly after Tsai visited with 6 of her confidants. Did no one really care about Tsai's thesis during that period of time, including Taiwan's education ministry? What about the 58 students Tsai advised when she was a professor? Did they not bother to read their instructors' thesis? The University of London gave itself another layer of protection when it said it carried out an internal review for Tsai's thesis in 2015. Back then, the conclusion was that the school no longer had Tsai's records, but that they were once handled by a now-defunct higher degree office. The school pushed the responsibility on a now non-existent office that can't be found. The degree Tsai showed is dated March 14, 1984, which doesn't match up with the University of London's graduation date of February 1984. There are so many unanswered questions and certainly many lies in between. However, Tsai won't take defeat sitting down. Last episode, we told you everything that happened during the latest court hearing in Taiwan. Judge Zhang Yonghui insisted on presiding over the hearing on June 10, 2022. Her intention was to close the case as quickly as possible. All 28 pieces of evidence brought forth by Tsai's lawyer Lien Yuanlong are photocopies. His side even submitted a picture of Tsai's thesis as evidence. They don't dare to discuss the contents of the thesis. Even though our lawyer Li Zhenghua pointed out potential forgery on Lien's side, Judge Zhang insisted on her course of action, which indicated she wanted to end the case as soon as possible. Only pressure from the presidential office could move Zhang to such urgency. As Tsai faced an uphill battle in the UK courts, she desperately needed a win, so she had to get Zhang to rule in her favor. Then there's Lien Yuanlong, who included LSE, ICO, UOL statements and the tribunal court's decision as evidence. None of those things are based on solid evidence. The UK hearing looming overhead, Taiwan authorities needed to preemptively score themselves a win. Judge Zhang wanted to rule in Tsai's favor based on nothing more than the University of London's statement, which might as well be thin air. Clear the wrongdoers have calculated their every move throughout these Taiwan trials. They've set up traps hoping we'd take the bait and move things down a path that's conducive to their goals. There are several outcomes the wrongdoers want. The first outcome is that Judge Zhang dismisses the case on the grounds that the plaintiff has no right to confirm Tsai's education credentials. That's also the primary plea behind Lien Yuanlong's case. Judge Zhang might follow through with the case in a superficial capacity, but as lawyer Jim Cheng has said, since the judge has already made up her mind, what point is there in trying to offer up an argument? How likely is it that Zhang will change her mind? The idea that the people don't have a right to a president's credential records has been debunked since October 2020 by Taiwan's High Court during an appeal. Let's go back to October 27, 2020, a time when ThesisGate was in the high courts. Back then, the presiding judge addressed the issue of interest and people's right to access Tsai's education records. Li Zhenghua and Jim Chang argued that because Tsai Ing-wen pressed criminal charges on the appellant, her education records were now vital evidence that could determine whether or not damages are merited. Lian's counter-argument was that since there was no harm to personal rights or well-being, there was no legitimate reason to request the personal and private information of Tsai Ing-wen. Because people's well-being or livelihood did not hinge upon the information requested, that information was inconsequential and could remain stored away. The judge then said that if the case Tsai brought forward in regards to her education moves forward, then there is legitimate reason for the information to be revealed. He asked both sides to assess the possibility of that outcome and to present relevant evidence for that contingency. Jim Chang pointed out that according to the law, if Tsai's thesis is proven to be legitimate, then it can offer her protection from future controversy and dispute. He said that the uncertain variables under discussion can be put to rest with the requested information. Lian Yuanlong said that the appellant lacked a legal and relevant ground for the basis of their case. He said that the defamation suit Tsai brought against her doubters and the case undergoing appeal were two different matters. That's because the charges brought against the appellant had yet to move into further stages that would require the information under question. The appellant currently bases their case off of speculation, nothing more. The judge then pointed out to Lian that the appellant does still face the risk of Tsai's charges getting pressed, so the information they request is still very much at play and relevant. Lian Yuanlong responded, saying that the defamation charges against the appellant does not hinge upon the information requested. He said that with or without Tsai's credentials, there's already a basis for establishing a defamation suit. It's true, the ThesisGate side had yet to be indicted in the case, but prosecutors could be brought forward to attest to the likelihood of the defamation suit's future. They could then speak to the necessity of the core information at the heart of the appeal and determine whether or not there is interest on the appellant's part. If Lian Yuanlong pushed to negate and void Tsai's libel suit against Dr. Dennis Pang, then Pang would not have grounds to request Tsai's education information. Coming back to today, Peng is not only indicted in the case, but he also has a warrant out for his arrest and faces 13 years in prison. So how is Lian going to spin the case to say that Peng does not have interest in Tsai's education? When the case was first brought to the High Court, the court actually downloaded a copy of Tsai's thesis at the National Central Library and asked whether or not the two sides wanted the High Court to continue hearing the case. They asked if the appellant wanted the High Court to hear the case. The High Court was well within its right to hear the case. It could take evidence from the district court and carry out an examination. But if the High Court had the right the entire time, why did it bother asking for approval and permission? Another scenario the wrongdoers might be looking for is to alter the central issue of the case. Judge Zhang may say that investigators do not have legitimate interest in knowing the requested information. She could then get the plaintiff to change the terms of their case under the guise of simplifying legal administrative procedure. At that point, the case's central issue could become about asking for evidence proving Tsai's degree and not about the existence of a 1984 thesis. With these changes, Judge Zhang can absolve herself of her first erroneous decision, which the High Court overturned. Lian wrote that making the central issue about the thesis is just a tactic the plaintiff is using to further speculate on Tsai Ing-wen's education. He said that the High Court, in its decision, insinuated that the thesis could not be used as a test of Tsai's degree. That means Lian and Tsai's defense will advocate for a case centered around proof of a degree rather than a thesis. Judge Zhang would ignore the fact that none of Lian's evidence are original documents and that the odds of that evidence being forgeries is very high. She would not carry out an evidence examination and grant Tsai a win in court. That is how the wrongdoers want things to play out. However, neither Judge Zhang nor Tsai's people ever expected ThesisGate lawyers to demand a promise from Judge Zhang that she would not end the case after one hearing. Additionally, filing a recusal request for Judge Zhang was also out of Tsai and Lian's calculations. The recusal request also took Judge Zhang off guard. In order to keep their plan alive, Judge Zhang acted as the decision-maker on her own recusal request. She said that the recusal request was just a stall strategy and insisted on hearing the case that day. Judge Zhang's actions show a blatant disregard for recusal procedure. Her deciding her own recusal was a failure of justice. Even Lien Yunlong realized that their plan had been so thoroughly derailed that insistence on carrying it out would only make his side look worse. Even after Jim Chang and Li Zhenghua withdrew from the courtroom, Judge Zhang offered to hear Lian's case uncontested, but Lian declined. Dr. Pang has decided to shelve the case for 4 months. As the case in Taiwan came to a pause, good news rang out from London. The courts there granted ThesisGate investigators a win. The UK court found LSE to be in violation of the Freedom of Information Act. Things are unfolding just as we predicted. Tsai Ing-wen's examiner name list came from Tsai's personal email and not from any school record or document. That email was sent on March 31st, 2021, and it did not come from 1984. March 31st, 2021 was the day Tsai filed suit against Peng. Next episode, we will dive into the UK court's findings. We will turn the tide. The truth is coming.